5 seconds to go. Start. There was not even a whisper of the allegation of the cruelty or the miscarriage caused by the appellants. The alleged incident took place in 2016, whereas the complaint was filed after the notice of divorce was given by the complainant, that is, in 2018. The latest alleged incident in the FIR is of the year 2016, wherein the most serious allegations under sections 312 and 313 of the IPC is raised. The explanation for the delay in filing of the complaint given by the complainant is that she did not want to spoil the marital relations. However, she has herself stated that she began residing separately and had moved out of the matrimonial house. Further, she had sent the notice of divorce on 15th May 2018. This would certainly mean that she believed that the marriage had broken down without there being any hope of reconciliation. It is difficult to believe that despite the complainant taking such drastic steps, she did not file the present FIR for another 6 months after the notice of divorce was sent. Moreover, the notice of divorce was completely silent about the allegations raised in the FIR, which was subsequently filed. The notice of divorce, on the other hand, contained allegations relating to the demand of money and jewelry from the complainant by the son of the appellants. It also contained vague allegations of physical assault inflicted by the son of the appellants. No allegation of cruelty or the miscarriage allegedly caused by the appellants was raised. These facts lead us to conclude that the proceedings were initiated with an ulterior motive of pressurizing the son of the appellant herein to consent to the divorce according to the terms of the complainant, and the proceedings were used as a weapon by the complainant in the personal discord between the couple. It would again be apposite to refer to the case of Dara Lakshmi Narayana Supra, wherein this court has discussed the objective of section 498A of IPC and has also raised its concerns over the misuse of this section in matrimonial disputes. This court observed thus: the inclusion of section 498A of the IPC by way of an amendment was intended to curb cruelty inflicted on a woman by her husband and his family, ensuring swift intervention by the state. However, in recent years, as there have been a notable rise in matrimonial disputes across the country, accompanied by growing discord and tension within the institution of marriage, consequently, there has been a growing tendency to misuse provisions like Section 498A of the IPC as a tool for unleashing personal vendetta against the husband and his family by a wife. Making vague and generalized allegations during matrimonial conflicts, if not scrutinized, will lead to the misuse of legal processes and an encouragement for use of arm twisting tactics by a wife and or her family. Sometimes recourse is taken to invoke section 498A of the IPC against the husband and his family in order to seek compliance with the unreasonable demands of a wife. Consequently, this court has time and again cautioned against prosecuting the husband and his family in the absence of a clear prima facie case against them. We are not for a moment stating that any woman who had suffered cruelty in terms of what has been contemplated under section 498A of the IPC should remain silent and forbear herself from making a complaint or initiating any criminal proceeding. That is not the intention of our aforesaid observations, but we should not encourage a case like as in the present one, where, as a counterblast to the petition for dissolution of marriage sought by the first appellant husband of the second respondent herein, a complaint under section 498A of the IPC is lodged by the latter. In fact, the insertion of the said provision is meant mainly for the protection of a woman who is subjected to cruelty in the matrimonial home, primarily due to an unlawful demand for any property or valuable security in the form of dowry. However, sometimes it is misused, as in the present case. We therefore hold that the continuance of the criminal proceedings against the appellants would result in an abuse of process of law. In the present case, the High Court has held that the allegations made by the complainant cannot be presumed to be false, and whether they are believable or not will be examined by the trial court. We hold that this was an erroneous approach taken by the High Court, as according to the principles laid down in the case of Bhajan Lal Supra, the allegations levelled in the complaint should at the very least be given a prima facie consideration. In the result, we find that this was a fit case wherein the High Court should have exercised its inherent powers under section 482 of the CRPC to quash the criminal proceedings. We are therefore inclined to allow the present appeal. We accordingly pass the following order. The appeal is allowed. The impugned judgment and order dated 23rd January 2020 passed by the High Court of Judicature at Bombay at Aurangabad in criminal application number 859 of 2019 is quashed and set aside, and the criminal proceedings against the appellants in FIR number 339 of 2018 and final report number 10 of 2021 on the file of Chief Judicial Magistrate Latur and all subsequent proceedings arising therefrom are quashed and set aside. Pending applications, if any, shall stand disposed of. Stop.